Distinguished guests, faculty, staff, and students of McLachlin College and York University, ladies and gentlemen, and of course, the Right Honourable Justice Beverley McLachlin, our 2019 Annual Public Policy Lecturer. Welcome to McLachlin College. As the head of McLachlin College, it is my distinct honor and pleasure to welcome you all to McLachlin College's 2019 Annual Public Policy Lecture. For those who are not familiar with our collegiate system here at York University, we have 9 colleges at York University: Founders, Vanier, Winters, New, Stong, Calumet, Bethune, Glendon, now called Glendon Campus, and McLachlin. Our collegiate system is one of the unique features of York University. And although I am biased, I would say it's one of the best features at York University as well. All York University undergraduate students are affiliated with one of the 9 disciplinary-based colleges, and McLachlin is one of the 4 colleges that is affiliated with the Faculty of Liberal Arts and Professional Studies. It's the college that is mandated to foster knowledge of and to analyze critically public policy. It is also dedicated to the improvement of society at all its levels: local, provincial, national, and international. Our McLachlin College Annual Public Policy Lecture is the premier event in our academic calendar. It features some of the most outstanding and distinguished public figures of our day who address significant public policy concerns that impact all of us. We are very fortunate indeed to have the Right Honourable Justice Beverley McLachlin as this year's lecturer. Thank you very much indeed for accepting our invitation and being here with us this evening. Our program this evening will begin with the land acknowledgement that will be delivered by our former head of the college, David Leighton Brown. This will be followed by our provost and vice president academic, Lisa Phillips, who will introduce Justice McLachlin. Following the lecture, we'll have a brief opportunity for some questions. This portion of the program will be moderated by Sean Courage, our Associate Dean here in our Faculty for Programs. Our Interim Dean, J.J. McMurtry, was unable to join us this evening and sends his regrets. Immediately thereafter, we shall call on Dean Mary Condon, who's the Dean at the Faculty of Law at Osgoode Hall Law School, to thank our lecturer. And afterwards, please take the opportunity to purchase a copy of Justice McLachlin's recently published autobiography at the close of the lecture this evening, if you haven't purchased one already. And we also have available for sale Ian Green's new book on Justice McLachlin's legacy on the Supreme Court of Canada. So without any further ado, I'm going to call on David Leighton Brown.
Thank you very much. I'd like to acknowledge that the land on which this lecture will take place has traditionally been occupied and cared for by a variety of Indigenous peoples, including the Anishinaabe, the Haudenosaunee, the Huron-Wendat, and the Métis. It's the subject of the Dish with One Spoon Wampum Belt Covenant, what committed all of those signatories to peacefully share and care for the resources of the Great Lakes region. May we continue to honor that commitment today. Thank you.
Hello, everyone. I'm so pleased to have a chance to be here to welcome you on behalf of the whole of York University to this 2019 McLachlin College Public Policy Lecture. This is just a signature event at York University, and it really is what the university is all about, to have students and faculty and staff and special guests from outside the university, community members to come and on a rainy night to come out in these kinds of numbers, hungry for ideas and debate and discussion. It's really a great moment for the university. I want to especially acknowledge that our President Emeritus, Ian MacDonald, I see is in the room. Thank you for joining us, President MacDonald. And to just also quickly acknowledge the very important role of this college and our liberal arts and professional studies faculty and many other programs in promoting the study of public policy issues so that our students are really coming into the world as really globally informed citizens who are going to help shape the important debates of the future. And the topic of this year's lecture, the role of a constitutional court in a modern democracy, is particularly important and timely in light of recent political developments in our country. Given the recent federal election where we have a liberal minority government, we may find, in fact, there's a more challenging role for the Supreme Court of Canada than would have been the case with a majority government, as well as not to mention the political environments in countries like the US and the UK that we keep a close watch on. The decisions of our Supreme Court affect us as individuals, as a society, in relation to our fundamental rights and responsibilities, are the most fundamental tenets of our social contract, equity matters, religious freedoms, education, business, and so on. Its work touches on the most pressing, the most urgent, the most difficult and necessary conversations in our society. So I am delighted, I could not be more pleased to welcome and introduce tonight's speaker, the Right Honourable Beverley McLachlin, former Chief Justice of the Supreme Court of Canada. I think that some of you are aware of her biography a little bit, but I'm going to make sure you all know that she grew up in Alberta. She earned degrees in philosophy and law from the University of Alberta, and then she went on to teach law at the University of British Columbia. In the early 1980s, she was appointed to the Vancouver County Court and then to the Supreme Court of British Columbia. Following an appointment as Chief Justice of the Supreme Court of British Columbia, she was sworn in as a member of the Supreme Court of Canada in 1989. And it was in the year 2000 that she was appointed as Chief Justice of Canada, the first woman to hold that position. She retired in December of 2017 as the longest-serving Chief Justice we've ever had in the country. Throughout her distinguished career, Justice McLachlin has demonstrated her absolute dedication to the principle of justice for all, regardless of race, gender, ability, or other differentiating positions in society, both in her own life and career and in the positions she has taken on cases that come before the court. Those cases have involved landmark judgments on issues as difficult and complex as equal marriage, gun control, free speech, assisted dying. There's only a few of the topics. Following her retirement from the bench since 2018, she has served as a member of the Court of Final Appeal in Hong Kong, finding herself yet again in the midst of very important unfolding world events. Somehow, in the midst of all that, she's found time to publish her autobiography, Truth Be Told, as well as a mystery novel entitled Full Disclosure. So we are most impressed and a bit in awe of the continued productivity. She was named in 2018 as a recipient of Canada's highest honor, the Companion of the Order of Canada. I'm very proud that she also holds an honorary doctorate from York University. I am really looking forward to hearing your reflections, Justice McLachlin, on your past experience, your insights for the future as well. Please join me in welcoming the Right Honourable Beverley McLachlin.
Thank you. Merci beaucoup. Thank you for that very kind introduction. Much too generous, I'm sure. But it is lovely to be here, and it's lovely to see this room so full on a very rainy and windy autumn night, and to see so many people who are interested in constitutional courts. Quite frankly, I've never imagined so many people would care about constitutional courts. So I'm very encouraged that you've all come out. It's also nice to be introduced to McLachlin College. If you ignore the spelling, I feel right at home. My first husband, whose name I took way back when, said the reason there were more than 13 spellings of McLachlin was that everybody was illiterate and they just wrote down whatever, or the clerk wrote down whatever happened to be in his mind when they entered the country. Be that as it may, it makes it difficult to keep track of McLachlins. And those of us who are happy enough to have that name often find our names misspelled, which may actually happen to McLachlin College on occasion, I suspect. Lovely to be here, and tonight I've been asked to talk about the role, as you've heard, of constitutional courts. Now, this, I'm going to say at the outset, I think is an extremely interesting subject, because constitutional courts, I believe, are vital to our democracy. And tonight I'll try to explain why. I'm going to begin just a few weeks ago, on September 24th, 2019. The Supreme Court of the United Kingdom issued a momentous and unprecedented decision known as Miller No. 2. The court unanimously set aside an order in council proroguing Parliament for the period from the 9th or 12th of September to the 14th of October on grounds that the Prime Minister's request to the Queen for prorogation was unlawful because it improperly prevented Parliament from sitting during a critical time prior to the date for the UK's exit from the European Union. In the days that followed, critics charged that the court should not have interfered with the matter because it was political. The divisional court had concluded that the issue was not justiciable. However, the Supreme Court said it was, affirming its powers as a constitutional court to rule on disputes between the executive branch of government, the Prime Minister, he representing the executive, the legislative branch, Parliament, and of course, the role of the court was implicated. The British had not been accustomed to thinking of their court as a constitutional court. They'd always talked about themselves as a parliamentary democracy, and the courts played some sort of ambiguous role in the weeds there, maybe sometimes. So this came as a shock to some. Indeed, the court below, the divisional court, had ruled the court had no jurisdiction to enter on the question. 2 points arise from the decision in Miller No. 2. The first is that there are two models, and this is just basic housekeeping background. There are two kinds of constitutional courts. One kind of constitutional court is what you find in Germany, it's a little bit different in France, continental model, where the Constitutional Court is a dedicated constitutional court. It does nothing but decide constitutional matters. And I visited the Constitutional Court in Germany, for example, and found it a very interesting experience, but one very different than my experience as a judge on the Supreme Court, which represents the second model of constitutional courts, which aren't really called constitutional courts, but they're Supreme Courts or courts which have constitutional responsibilities. So just to be clear, for the purpose of this lecture, when I'm talking about constitutional courts, I'm talking about both kinds. The kind of constitutional court we now know we have in the United Kingdom, because they took on that role and stated it very clearly in Miller No. 2, and the kind of dedicated constitutional court we find in some countries. The second point that I think arises out of Miller is that constitutional courts, regardless of what form they take, have important powers that can and often do impact political issues. The decision in Miller No. 2 meant that the Prime Minister could not act unchecked in negotiating an exit to the European Union, and restored to Parliament a voice in the matter. And we see in today's news where that has led. Parliament has indeed acted in a way that has resulted in a call for a new election on December 12th. In Germany, a few years back, a decision of the Constitutional Court invalidated the country's social benefit scheme. It was such a dramatic thing, on the ground that its provisions were too niggardly. And in Canada, as I will discuss in more detail in this lecture, the Supreme Court of Canada has played an important role, a critical role, on a number of fronts touching on legislative and political matters. The fundamental role of constitutional courts, regardless of model, is to ensure that government powers, state powers, legislative and executive, are exercised in accordance with the Constitution. The requirement that laws and government acts conform to the Constitution is a basic tenet of the rule of law, which requires that all state power be exercised in accordance with the law. The Constitution is the primary law of the land, even if, as in the United Kingdom, it may not be stated in a fancy document, but more by conventions. Therefore, government laws and executive acts, even the acts of the Prime Minister, must conform to those conventions, to that constitutional law. And the task of deciding whether this is the case falls to the constitutional courts. Constitutional courts are thus a necessity in a democracy based on the rule of law. They ensure that state powers are indeed exercised in accordance with the law. This brings me to constitutional courts in Canada. All courts created under Section 96 of the BNA Act, Trial, Appellate, and Supreme Court of Canada, are courts of inherent jurisdiction. That means undefined, residual, and thus have the power and the duty, when asked, to rule on constitutional issues. Now, these issues fall into three categories. The first are issues on the respective powers of the provinces and the federal government. We call these federalism issues. The second are issues relating to constitutional guarantees of rights under the Charter and provisions for other rights, like the guarantee of Indigenous rights in Section 35 of the Constitution Act 1982. These are constitutional. We're going to have to tell those people to, this is very difficult. These are rights-based issues. And the third kind of issues are issues relating, and this is what was involved in the Miller number 2, to unwritten constitutional provisions and the exercise of prerogative powers of the Crown. So tonight I'm going to take a brief survey of how the Canadian Supreme Court and other courts on the way up have dealt with issues under these three heads: the federalism issue, do the provinces have the power or the federal government, the constitutional guarantees of rights, and this last ambiguous category, issues relating to the exercise of prerogative powers of the Crown. So let's start with federalism issues. Since the creation of Canada in 1867, courts have been ruling on the constitutional powers of provincial and federal governments under the British North America Act, Section 91 and 92. These sections set out the respective powers of the federal and provincial government, and they are of vital importance. When disputes arise as to whether a particular law or government act is within the power of the government that made it, the courts resolve these disputes. So Canada has a long history of constitutional litigation on what powers the provinces have, what powers go to the federal government. And it is a really interesting story, as I'll share with you in a moment. What was conceived as a highly centralized federation, Canada in its beginning, has in fact, over the course of a century, become a decentralized federation. How has this transformation come about? The architects of the Canadian Constitution conceived the new country as a federation in which the provinces dealt with largely local matters, while larger questions involving the country as a whole were left to the federal government. This is evident not only in the broad drafting of the specific powers of Section 91, which confers power on the federal government, like transportation, foreign affairs, and the Commerce Clause, but in the conferral of residual powers. In other words, if something comes up and nobody knows who should deal with it, It's the federal government, peace, order, and good government, which is sometimes referred to as inelegantly as the POG. However, so we started off with this centralist version. We're going to have one big unified country. The provinces will deal with little local matters, but you know, it's not going to be like America before the Civil War with states' rights and all that. It's going to be a strongly centralized country. I think that was the vision of the founders of Confederation. However, the Judicial Committee of the Privy Council, which until 1949 was Canada's final court of appeal, turned the original intent of the framers on its head by construing provincial powers, and this is a general statement, there are exceptions, broadly, and federal powers quite narrowly, and limiting the use of the federal residual powers. Many, although not all, of the English judges sitting on the Judicial Committee around the turn of the century exhibited a states' rights orientation that tilted Canada's constitutional balance in favor of the provinces. It is interesting to ask why this happened. The leading factor may have been the US Civil War, which raged from 1861 to 1865, just as the negotiations for the Canadian Federation were taking place. It seems clear that the lesson the framers of the Canadian Constitution drew from the US Civil War was that a strong centralist government was required to keep the new nation together and prevent a similar cataclysm in Canada. However, some of the judges of the Judicial Committee of the Privy Council, notably Viscount Haldane, who was very influential, drew the opposite inference from the Civil War, that the cause of the war was the imposition of a broad federal authority on a country originally conceived as a collection of semi-autonomous states. At the end of the Civil War, Jediah H. Benjamin, one of the most fascinating figures, I think, in this legal history in this time, an influential lawyer who had been part of the Confederate government, he was the Attorney General. When Jefferson's government, when the government fell, Benjamin fled to England to escape death. He became a prominent figure at the British bar and close friends with many of its judges. He brought his states' rights philosophy with him. The result may have been, and I'm speculating here, I'd love to do more research on it, but the result may have been to convince many British jurists that if Canada was to have a future, provincial powers must be broadly interpreted and the residual powers of the central government restrained. Whatever the cause, the Judicial Committee of the Privy Council in the formative years of the Canadian Constitution gave a narrow interpretation to the federal commerce power, the federal transportation power, the federal foreign affairs power, and the peace, order, and good governments clause, while construing provincial powers broadly. Some decisions went the other way, but this was the dominant trend. When appeals to the Judicial Committee of the Privy Council were abolished in 1949, the Supreme Court of Canada finally became the final constitutional court for the division of powers between the provinces and the central government. But by then, the die had been cast. Canada would never be the centrist power the framers of its constitution had dreamed of. The narrow interpretation of federal powers and the broad approach to provincial powers had the consequence of creating an asymmetry between the taxation scheme of the BNA Act and the allocation of powers. The federal government, with restricted powers, had a broad, unlimited power of taxation. The provinces with broad powers were restricted to direct taxation. In the second half of the 20th century, this asymmetry led to shared power schemes that we call cooperative federalism, in which the federal government provided funds to the provinces to do what they now had to do. The Canada Health Act is a notable example. Another consequence of the decisions of the Judicial Committee of the Privy Council that curbed the federal powers in favor of provincial powers is that the thesis prevalent in the United States, and we hear a lot of this, that the Constitution should be interpreted in accordance with the intention of the framers doesn't work very well in Canada. I've had law clerks come to me and say they've been educated, these people who are asking this question, in the great schools of Yale and Harvard, and they say, why don't we talk about originalism in Canada? And I tell them, if we did, we would turn our country upside down. To interpret the Canadian Constitution on division of powers according to the intention of its framers, one would have to override more than a century of jurisprudence. The interpretations of the Judicial Committee set the framework on which federal-provincial relations, the economy, and social projects have been built over the decades. Courts are also bound by precedent, and they cannot simply undo this project because they think the original drafters of the Constitution intended something else, or even that its clear language seems to intend something else. If they were to try, chaos would likely result. Canadian scholars, influenced by their colleagues to the south, sometimes argue for originalism in this country without perhaps fully appreciating the consequences it would have. The Supreme Court of Canada may not have been able, assuming it had so desired, to reverse the diminution of federal power the Judicial Committee of the Privy Council worked. But it continues to play an important role in Canadian constitutional interpretation. The most important case of my time was the secession reference of 1998. Following a close result in favor of remaining in Canada on a Quebec referendum, the Government of Canada, many of you will recall this, asked the court to rule on whether a province could unilaterally secede from the country under Canadian law and under international law. The court said no to both, but went on to hold that the fundamental principles upon which the Canadian Federation was based, the democratic principle, the principle of the rule of law, the federal principle, the principle of protection of minorities, would require the federal government to sit down and negotiate with a province on secession, provided that there had been a clear majority, whatever that means, the court left to the politicians, on a clear question. And those who have studied this or recall it know that the question in the particular referendum that preceded this reference was anything but clear. Since this ruling has since been embodied in the Clarity Act, and it's perhaps one of the most read and studied constitutional decisions of the Supreme Court of Canada, because there's very little literature on secession in any courts, in any place in the world, and the decision of the court and how they relied on these fundamental principles in interpreting what should happen in the case that there was a clear desire on a clear question for separation have guided or at least been discussed by many courts and many scholars around the world. And in the end, in that result, it was a very delicate situation. There were no precedents, and I was on the court. We feared very much that whatever we said, it would make the problem worse, which is the last thing courts want to do. But I'm happy to say that, in fact, the decision was relatively well received, both by those on the federal side and by the province of Quebec. And that it, I like to think, provides a uniquely Canadian perspective to the problem of secession. We know what's happening in Spain now and certain other countries. But the Canadian approach set out in the secession reference says, if you're really sure about this and you're really clear on it, we have to sit down and talk. And that is so Canadian. So that's the first place that constitutional courts play an important role in determining the powers that the provinces have, the powers that the central government have, who can do what, and what happens if part of the Federation wants to leave. I can tell you that it's been fascinating work. I've always found these questions while very difficult and sometimes frustrating, given the history of some of the precedents, juxtaposed with the language, which seems to point other directions. But it's been wonderful work, and I think it is fundamentally important. And I came to realize that you cannot have a federation, an operating, functioning federation over that without a strong and independent constitutional court. It simply won't work, because from time to time, tensions will arise between regions. Difficulties, good faith differences on who gets to do what under the language of the Constitution will arise. And you have to have an independent, impartial body to decide those questions so you can move forward together as a nation. Let me turn to the second subject matter category that constitutional courts engage in, and that is rights guarantees. Now, not every country has a constitutional Bill of Rights, but even in those countries like the United Kingdom, you find the courts saying that it is so deeply embedded in our Constitution that people have certain rights: the right to a fair trial, the right to a modicum of equal treatment, the right to free expression. But in our country, we have, since 1982, the Charter of Rights and Freedoms, as well as Section 35 of the Constitution Act, which create clear constitutional rights. Now, the Charter and the sections say to people, this document is giving you fundamental rights that the state can't take away, except, and then you get to Section 1, which says that if the state can show that a limit it places on the rights is demonstrably justified in a free and democratic society, then that limit will be upheld. And this is very, very important, because no rights are absolute. The United States Constitution, under its amendments, tends to state the rights in absolute terms. No person shall interfere with freedom of speech. But we know that sometimes there have to be some limits on freedom of speech. The law of defamation is one. You can't simply go slandering people. The famous example of Holmes of falsely crying fire in a crowded theater is another. And we have hate speech limitations and others that most Canadians would support and most civilized societies would support. So when you're talking about rights, you're always talking about balances, and you're talking about limits, and you're talking about how far can the state go in entrenching on those rights. And deciding where those balances or those limits are is the quintessential role of constitutional courts. Now, the framers of the Constitution Act 1982 had a choice. They could have gone the American route and stated the rights in absolute terms. You have an absolute right to freedom of expression. You have an absolute right to equality. You have an absolute right to whatever. But they didn't do that. They followed a more European model, which recognized that rights have to be inherently limited. And they provided in Section 1 a test for determining what the extent of those limits would be. Now, the Americans had no test. And so what happened there is that the United States Supreme Court, over the centuries, has worked out internally, within the guarantee of free speech, for example, or whatever it may be, internal limitations. But we took a very different approach in Canada. Now, this was a big change for our constitutional courts. Up till this time, the court, our constitutional Supreme Court of Canada and the lower courts that were called upon from time to time to rule on rights issues, really didn't do so in a constitutional sense. The Diefenbaker Bill of Rights was a big disappointment to many who advocated a fulsome and vigorous approach to rights. Nothing much came of it because it was just a piece of legislation, and the court took a narrow view and said any act that came after it was inherently an amendment to the Bill of Rights and therefore took precedence. So there had been disappointment over that. And Prime Minister Pierre Trudeau said, we want to get a constitutional Bill of Rights that will remedy that. Not everybody was happy with that, because some people said, watch what you're doing. You're going to give the Supreme Court of Canada a huge amount of power that it never had before. In addition to ruling on division of powers issue, the court is now going to get to rule on rights issues and look at those rights. They're broad. Liberty, the right to free expression. They'll get to rule on all of those things and sometimes say the legislation is inconsistent with the Charter and fails, or that government acts violate the Charter and fail. And those people said, yes, Section 1 is good, the courts can rule, but we don't trust the courts very much. So they also put in they insisted, and this was one of the conditions of getting the deal done, Section 33, the notwithstanding clause, which is currently in the news, as you know. So when the Supreme Court of Canada, and I was not on the court at the time, found that the Charter was adopted, it found itself faced with a huge number of choices. The first question was whether the court would do what the United States Supreme Court had done and spend a lot of time defining the rights within the right. What does freedom of speech mean? You see a little start on that in a case called Irwin Toy, but it didn't really prevail. Generally, the court adopted a very broad purpose of rights, so it was very easy to establish a limit, a government act limiting that right, or that a law limited a particular right. Very easy to get through that part. And then you went to Section 1 under the method that the court chose, and that's where a lot of the heavy lifting has been done under our Charter. Now, it could have been otherwise, and you can mount a pretty good argument that it would have been, some people say, better to have done the definition within the rights, because Section 1 is a fairly broad power, and it courts tend to divide on it, suggesting there's a subjectivity to it in practice. But anyway, that's the way we have gone, and that was the first approach, which meant that our rights would be broadly and fulsomely interpreted, but also put a lot of burden on the state under Section 1 to justify limits. Nevertheless, the court's charter jurisprudence has had a transformative impact on the country in the decades since the charter introduction, an impact that polls suggest Canadians appear to generally support. We've already heard some of the rights in the introduction, but same-sex rights, LGBTQ, right to assisted dying, expressive rights, rights to protections in the criminal justice system, and I could go on, political rights, we can go on and on. All of these have been considered and ruled on by our courts, and in particular to the Supreme Court of Canada. And equality rights have been particularly important, something I think was never conceived except to the extent we had anti-discrimination bills of rights in the provinces. Very, very important under the Charter, and has completely, in some ways, changed our legal landscape. Enhanced liberty rights are also a product of this. So, there's a lot to be said on the rights. The court has been very busy throughout the 30, 35 plus, whatever years, the Charter has been in litigation. A generous approach has prevailed, and Canada's Constitutional Court is now regarded as having built up a broad and generous panoply of rights protections for this country. But there's another right that is also important. It's not actually included in the Charter, but it's really changed the country. And the Supreme Court of Canada, as a constitutional court, has had a huge role in doing this. And that rises from the court's rulings on Indigenous rights under Section 35 of the Constitution Act 1982. Excuse me. Now, Section 35 is an interesting section, and it says that existing Indigenous rights, excuse me, I have a tickle in my throat. Existing Indigenous rights are protected. And people who are worried about too broad a guarantee in the drafting of the Charter insisted on that word existing. Why was that so important? What does it matter, a little word like existing? Well, the argument that was mounted in a case called Sparrow was that existing meant that the only Indigenous rights were protected were those Indigenous rights that were recognized by the courts after 1982. Not too many Indigenous rights had been recognized before 1982, despite attempts under the Bill of Rights, the Dry Bones case, that sort of thing. So conservatives who worried about shifting things too much said, we need to have this limitation, existing rights. And in Sparrow, they argued that this meant that, as I say, the court could only look at rights recognized after. Treaty rights back then? No. Hunting, fishing rights back then? No. Land use back then? You're out of luck. That was the critics' argument in Sparrow. But the court rejected that in Sparrow. And the court said that the intention of the provision must be to protect all Indigenous rights, even though they may not have got the good housekeeping stamp of approval by the courts prior to 1982. Now, this opened the door to transformative rulings on Indigenous land claims, claims based on Indigenous practices and treaty rights. The present project of reconciliation upon which this country is embarked owes much to this jurisprudence. And taking part in the development of this body of law has been one of the most satisfying experiences of my life. One cannot leave the role of Canada's constitutional courts in rights decisions under the Charter without saying a few more things about the notwithstanding clause, Section 33, which gives Parliament and the legislatures the power to override court rulings on rights infringements for a renewable period of 5 years. The anomaly of giving rights and then allowing the state to take them away, even where it cannot justify this under Section 1, has not been lost on commentators. However, in the almost 38 years since the Charter's adoption, Section 33 has been seldom invoked. The only major example prior to C-21 being its use to override the Ford decision, which held that Quebec's language law violated the guarantee of freedom of expression. As a result, there has been virtually no jurisprudence on the interpretation of Section 33. This may soon change as litigation goes forward, and it is going forward, seeking declarations that Quebec's Bill C-21, which imposes restrictions on religious dress in public positions, is unconstitutional. We will wait to see how the courts respond to this very interesting challenge. Let me move on to the third area where constitutional courts are active, And that is in dealing with, and I've lumped these together, although conceptually they're perhaps different in ways, unwritten constitutional provisions and the exercise of prerogative powers. Now, first-year law students are sometimes taught or led to suppose that the Constitution is found in two documents, the BNA Act of 1867, which founded our federation, and the 1982 Constitution Act, which brought us, repatriated the Constitution, brought us the Charter, Indigenous rights protections, and other protections. But they would be wrong, because while Canada has a written Constitution, the Constitution is not fully contained in the BNA Act or the Constitution Act 1982. Other statutes have been held to contain provisions of constitutional force. For example, most scholars agree that the Supreme Court of Canada could not be constitutionally abolished, that it's become a constitutional fixture in our Constitution, relying on the Supreme Court Act read in the context of Canadian democracy. Now, this is very interesting to me. It used to be interesting when I was on the court. Not that I ever feared they'd try to abolish it, but there was such a case. The court was created in 1875, 8 years after Confederation. It was kind of an afterthought. But they had the Judicial Committee of the Privy Council, so it wasn't imperative they get around to it right away. And then a few years later, there was a lot of opposition to it, and a few years later, there was actually a bill in the House to repeal the Supreme Court of Canada, to end the Supreme Court of Canada. And it was hotly argued. You can go into Hansard and see the arguments. Useless court, we don't need it, costs a lot of money, hardly any cases. The first sitting of the court, the record records, the court convened. There being no cases, it rose. And that's about it, a whole session of the court. The language is slightly different. There being no business before the court adjourned. But in the interim years, the court has become, and is accepted by most, as an essential part of our Constitution, particularly now since we don't have appeals to the Judicial Committee of the Privy Council. Now, in addition to these kind of constitutional provisions that we deduce from statutes and context, there's something called constitutional conventions. Now, this is really complicated and I won't go too far down, but conventions are not just practices. They are ways of operating that have become so much part of our democracy that you have to follow them. For example, a government cannot continue to govern if it does not enjoy the confidence of a majority of the House of Commons, if it can't get its bills through. That's not written anywhere in the BNA Act. It's not written anywhere in the 1982 Act, but we all know it, just like the Brits know it, because it was part of the British parliamentary system that we inherited. And that's what we call a constitutional convention. Now, there's not much of a history of courts ruling on constitutional conventions, but it is another form of constitutional rule, which conceivably people could try to test in courts. I'm not saying whether they'd be successful, but it could be at least argued to be litigible, which gets us to the kind of murky boundary line that was being explored in Miller number 2. In addition to these statutorily derived provisions and conventions, courts may be ruled in some circumstances to rule on the exercise of prerogative powers of the Crown. Now, what are the prerogative powers of the Crown? I think the theoretical explanation is that as Parliament took increasing powers away from the monarchs in England, they didn't take everything. And there were still some residual things that the Crown could do that have never been taken away. And those are exercised generally by the Prime Minister and the government in the stead of the ancient monarchs. So these prerogative powers are very interesting from the point of view of constitutional courts. There's been little scholarship on them. There's a great book that was written just last year, but it's an area that is rich in questions that need to be better explored. Some exercises of the Crown prerogative have been held to be non-justiciable. In other words, you can't test them in the courts, you can't argue them in the court, beyond the powers of the courts. The power to conduct foreign policy is one example. Some of you may remember a case, I believe in the 70s in the Supreme Court of Canada, Operation Dismantle, an important case. United States and Canadian government had agreed that the United States could test its cruise missiles over Canadian territory in the north. People who opposed war and opposed this in Canada brought a lawsuit. And they asked the, actually this was in the 80s after the charter, I'm sorry. And they asked the court to rule that the government could not lawfully do this under the Constitution. And the court said it would not enter into the question. It was a matter of foreign policy, and that wasn't the role of the courts. It wasn't exactly that the court didn't have the power, but it wouldn't be appropriate to have judges second-guessing governments on matters of conduct of foreign policy. And the other area, there was a case called the Crown versus Black, which may raise some resonance not long ago in the Ontario Court of Appeal. And the Ontario Court of Appeal held that the courts wouldn't get involved in reviewing conferral or revocation of honors by the Crown. In other words, they weren't going to go there again. So there are some prerogative powers where the courts will not entertain appeals. So that brings us back to the decision of the United Kingdom Supreme Court in Miller No. 2. Because what was at stake there was a prerogative power. And the argument accepted by the divisional court was the courts shouldn't interfere in this. This is a political matter. The courts have no business in this. The main issue in the case was justiciability, whether the court had the power to rule on the legality of the Prime Minister's prerogative power to advise Her Majesty to prorogue Parliament. The Supreme Court held that it had that power, and it stated, and I quote, "As long ago as 1611, the court held that the king, who was then the government, hath no prerogative but that which the law of the land allows him." The question before the court was what limits lay on Prime Minister's prerogative power to advise the Queen to prorogue Parliament. The court held that the power to prorogue Parliament is limited by two constitutional principles. The first is that the exercise of the prerogative power must not undermine the sovereignty of Parliament, and the second is that the Prime Minister is accountable to Parliament, basic political theory, for his conduct. By asking for prorogation, the Prime Minister had violated both those principles. He was trying to do an end run around Parliament having a say in leaving the European Union, which he hoped to accomplish by October 31st. And he was making He was insulating himself from being answerable to Parliament. This was something the court said that as a constitutional court, it had the power to rule on. The fact that the result had political implications, enormous political implications, did not negate this. Now, if you fail to understand everything I've just said, you're to be forgiven. The law concerning review of prerogative powers is complex, and one on which some scholars differ. But the basic proposition, and one I think can be justified and upheld, is simple. All government acts must conform to the Constitution, and the courts have the power and the duty, if called upon, to rule on whether that is the case. The court's duty ultimately is to protect the Constitution and the application of the Constitution in the land. The rule of law requires no less. Let me conclude. Canada, as a democracy grounded in the rule of law, possesses three branches of governments: legislative, executive, and judicial. Each branch is essential to the functioning of our democracy. Each branch must fulfill its unique duties to the best of its ability. And each branch must respect the role of the other branches of government. Together, the three branches work in complementarity to preserve a functioning constitutional democracy. Constitutional courts seldom get the big billing that parliaments and prime ministers receive, but they play a vital role in our democracy. They rule on the limits of federal power. They maintain our rights and freedoms, and they ensure that state officials act within the limits of the most fundamental law, the Constitution. However, constitutional courts in some parts of the world are a threatened species. Constitutional courts are only truly functional constitutional courts if they are independent of the other branches of government. This independence is being challenged, particularly in Eastern Europe. One thinks of Hungary, Poland, Russia, where courts have been more or less, by different legislation and different means, brought under the thumb of the executive. And only, I just read it 2 days ago, but only this week, I believe, perhaps last week, the Ukrainian parliament passed a law that essentially put its constitutional court under the power of the executive. This is the constitutional court that stood up very strongly during the days of the Orange Revolution. And its judges had great experience in how constitutional courts function, and Canada was part of training and education of that. Now we have a law that says that court that acted courageously in the past must do whatever the executive wants. And that, I believe, is fatal to its continued functioning as a true constitutional court. So I close with a rather sobering thought. Constitutional courts can be undermined. Some even argue that the increasing politicization of the Constitutional Court, that is the Supreme Court of the United States, may be subtly having the effect of bringing it more and more, leaving more and more ground to the executive as opposed to the judiciary. For example, when you have courts saying we're not going to rule on gerrymandering or on whether certain limits are. I leave that to you to consider, but to me it's a fascinating question. Well, I must stop. I've gone on long enough. I want to thank you very much for allowing me to share my thoughts on a passion that not everybody is excited about, but I am very excited about, which is the role of constitutional courts in our world order. Thank you.
Well,
I want to first thank, on behalf of the Faculty of Liberal Arts and Professional Studies, thanking the Right Honourable Beverley McLachlin for joining us tonight and generously sharing her passion for constitutional courts and anticipating a question that I have as well with her concluding remarks. But each year here in McLachlin College, we strive to invite speakers with extraordinary knowledge and expertise in their fields to York University. And once again, we are so fortunate to have the 17th Chief Justice of Canada with us here tonight, sharing her thoughts. These kinds of events and activities breathe life into the mission of York University and the mission of our faculty, so we're really grateful for that. This is an excellent opportunity for students in our programs like Law and Society, Public Policy and Administration, Criminology, and more. And I know that tonight's talk has ignited a lot of conversation, and so this is an opportunity to ask some questions. And I thought maybe I would get the ball rolling asking if you'd be willing to expand a little bit about your concluding remarks, because I was curious to hear from you what you thought about the relationship between constitutional courts and the emergence of populism.
Well, obviously, people who ascribe populist regimes don't like courts, because really what I've described in our system is a system of checks and balances. And what the Miller case was all about was checks and balances. The Prime Minister can't do an end run around Parliament. What's the proper order of our democracy? Populist regimes don't like checks and balances. They want to have all the power in the executive or in a legislature controlled by the executive, generally speaking. So, yeah, they don't like them, and they find ways to undermine them or get around them.
Okay, so we've got a microphone here in the center, so if you want to step up to the microphone and ask your question.
Thank you very much, Madam Speaker. Madam Chief Justice, good to see you again. Thank you for that very interesting presentation. And of course, I should say thank you for your role in having raised the profile of the court as an honest broker in Canadian law and Canadian government. I'm glad to see you recognize the Supreme Court as a constitutional court in federalism, balancing and limiting rights, and the role of the Crown, unwritten principles of the Constitution. Given that recognition, and as a constitutional court judge, what would you say your legacy is to the development of the Canadian Constitution from the bench?
Oh, well, that's a big question, and history will say. But, you know, I think that I have played a role in all of those three areas, and so we'll see what judgment history puts on that. But I think more broadly, the Canadian court has, I would like to argue, I'm no longer a judge there, but I think it's taken its responsibilities very, very seriously and tried to act with in a measured but forceful way when necessary, and in a respectful way, because one of the primary considerations that I always thought and my colleagues held dear was that, you know, each branch of governance has to respect the other in order. So we would have many long passages in our decisions on rights, for example, on deference to the choices of Parliament or the legislature on socioeconomic problems. Judges can't deal as well with those issues as the elected representatives. So we tried very hard to play our role without faltering or avoiding important legal issues, but also with deference and respect. And we hope the Parliament and the executive act in the same way toward the judiciary. Thank you.
And my former Professor John White sends his best wishes to you.
Oh, thank you. Wonderful. Thank you.
Madam Chief Justice, first of all, thank you for, as I've grown up, inspiring my confidence in this country, and thank you for continuing to do so. So, my question is, after the SNC-Lavalin scandal, do you think that has any bearing on the constitutionality of courts in Canada, or do you think that's affected their strength?
Well, it never affected the courts. No, I don't think so. I
Okay.
mean, I think everybody understands on all sides of that issue that courts have to be independent, and similarly, I think other aspects of the justice system, prosecutorial and so on, have to be independent. The really argument was there enough interference to really make it bad, and so on. So I'm not going to wade into the rights and wrongs, but the principle is clear. You have to be independent. So in the United States, sometimes it's less and sometimes it's more. I mean, there are those who might infer that at times the President of the United States is not approaching the role of the Attorney General, for example, in a totally independent way. He'd be much happier with an Attorney General. He keeps changing them. One might infer that he's looking for one that will be more sympathetic to him, and perhaps he's found him. But, you know, this is the issue, independence. We have to have an independent justice system. Thank you.
Thank you kindly.
Good evening, Madam Chief Justice.
Yes.
It is truly an honor to be here, and I'm very happy a lot of people have come out and, to listen and hear your wisdom, especially as a very long-serving Chief Justice on the Supreme Court. My question for you, by the way, sorry, my name is Mohammed. I'm an MA student here in political science. My question to you is, of course, when we talk about constitutional courts, on a general level, they're very important. Now, I want to delve into the inner workings of the constitutional courts. Given your, impeccable record at achieving so much consensus in the court, I wanted to ask, how important is it to you that the justices on the Supreme Court or in any constitutional court can talk with one another and achieve a consensus? And what role does that play, especially in the role of Canadian federalism and democracy?
Good question. Well, we have a long tradition of dissent. If a judge really doesn't agree with the majority, she can dissent, and that has to be respected. But when I was on the court, I worked very hard, particularly, and before me, people worked hard, particularly on the really important, sensitive cases to get as much consensus as possible. So the secession reference, I wasn't Chief Justice, someone else was, but we worked very hard. So on that very sensitive issue, we could speak with one voice, because if there is a dissent or two, the judgment can lose its force. And some people, critics, will argue, well, it's not all that clear, and the power of the majority judgment may be impugned. And it's very, very interesting on Miller case. The United Kingdom Supreme Court had, I don't think ever before, sat as a full court. One person was missing. But their tradition is to sit in benches of 3 or 5, and there are 11 people on the court. And they have always done that. And I talked with them about it on visits and so on. They said, no, we like our way of doing things. And they said, well, you guys, you're always looking for unanimity. We don't care. But on this very sensitive decision, Lady Brenda Hale, who's the president of the court, whoever caused it, I assume it was she, but anyway, they sat the whole court and they were unanimous. And I think that added a lot to the acceptance of the decision, because certainly if you looked at the British press, there were many critics, but if the whole court said that, well, there's not nearly as much ammunition, not nearly as much doubt, and people move on. And that's part of the rule of law, too. You don't have to agree with the decision if you're a member of the government or the executive, but you will accept it. And so I think that's what we saw in that case. Thank you.
Thank you very much. Have a good evening.
Hello. My question is about the modernization of the Indian Act. My little girl has autism, and the Indian Act refers to her as a mentally incompetent Indian.
Yeah.
And for myself and for her, the idea of that label If anything happened to me or my husband, the only person responsible for her is the minister, not a minister's delegate, not a committee. So in terms of your opinions of modernizing the act to potentially allow a committee to take care of my little girl if something happened, instead of just one person, my question is, sorry, in terms of modernizing the act, there's always two pathways. First, of course, is the courts. The other is through the parliament. And just your opinions on which way realistically for me and for other autism families that can move ahead, sorry.
Yeah, great question. I hear you. And I think it's probably fair to say that most people would agree the Indian Act needs, it's a product of the past. And, you know, but it's nothing, the courts can't really, except on specific rights issues where they have ruled the act is contrary to the charter, and I'm not giving legal advice here, but there might be an avenue. But the main responsibility, I think, has to be with our legislators. And I know it's complex and I know it's difficult, but eventually we're going to get around to it. We're going to fix this. And we need to look at it. Thank you.
Thank you.
And I feel your pain.
Sorry.
Ad nauseum, you're going to hear this, but thank you so much again, Justice
Yeah, thank
McLachlin,
you,
for
thank
coming
you.
and speaking here.
Very kind.
My question, in no specific terms, has some relevance to SNC-Lavalin, but I won't mention names. So do you believe there is, at any point in time, justification to violate cabinet confidences or...
I don't give legal opinions anymore because I'm not a lawyer. I'm not even allowed. You know, the law on cabinet, there may be a couple of little exceptions. I haven't looked at it, but generally speaking, it's pretty solid, and I'm not going to. I'm not qualified to give an opinion on that. I'm so sorry.
Okay, thank you so much.
Oh, okay. Hi, my name is Matthew. I'm a first year public policy and administration student. And I want to ask about your experience in Hong Kong and your comparison to the constitutional law here. What makes Hong Kong basic law like stand out and different from your experience in Canadian law? And also from recent events, do you think like the recent Hong Kong government using the Emergency Act to ban on the public of using masks to cover themselves? Is this an abuse of power?
Well, I might have to rule on that, so I'm obviously not going to be able. But thank you. Finish your question, please.
Yeah, that's my question basically.
Okay. Well, I'll explain the background because not everybody may know it. I have been appointed as an external judge on the Hong Kong Court of Final Appeal. The 1997 agreement between Great Britain and China for handover in 50 years from then guaranteed British-style courts, independent courts, and as part of that, there was provision for an external judge from another country to sit on the Hong Kong Court of Final Appeal at all times. Mostly these have been British judges, but I was asked to do it, so I agreed to do it. I haven't been over there yet, so I can't answer the first part of your question. I'm going on November 21st, and I'll be there for 4 weeks, and it'll be very interesting to see. But everything I hear and read says that the courts remain independent and impartial, and there's been no interference with their powers. And it's basically a British-style system of court. It applies the common law plus local edicts, and that's about as much as I can. I intend to go there and act as a judge impartially and independently and do my job. And beyond that, I can't comment on the situation. Thank you very much, though.
Thank you anyways. Thanks.
I do see that we have a line of people still, but we do have to close off the questions at this point, but I'm really grateful please join me in thanking the Right Honourable.
So good evening, everybody. My name is Mary Condon. I'm the Dean of Osgoode Hall Law School here at York. I think that the lecture that has been delivered by Chief Justice McLachlin this evening has been historically rigorous. It's addressed some very important questions about what entity is the appropriate decision maker for some very fundamental questions about democratic government in Canada. She's also addressed questions of how to balance conflicting rights. She's talked about the very important issue of the development of Indigenous rights in Canada, the attempt to use the exercise of the prerogative power to limit the role of constitutional courts, and finally, of course, the importance of the independence of constitutional courts to a functioning democracy. And I think that the question and answer period has shown in particular that it's been extremely inspiring for all of us to be in the presence of and to listen to someone who has dedicated her life to distinguished service to the rule of law, to the legal system, and to Canadian society more generally. So Chief Justice McLachlin, I want to thank you so much for your visit to York University today and to please accept this small token of our appreciation.
Thank you. It was a pleasure.